All right, let's talk about India's new criminal code. Ever wonder what actually happens right after a serious crime gets reported? In those first crucial moments. We're going to break it down right now.
So, when a big crime goes down, who calls the shots? Who really decides if there's going to be an investigation? You'd probably say the police, right? Well, it's not that simple. There's a really important check and balance in the system, one that might surprise you.
Okay, so the whole thing kicks off with a document that honestly most people have never even heard of. It's not the famous FIR, the First Information Report. No, this is something that happens even more immediately, and it goes straight to a judge. It's called an occurrence report.
So what is this thing? Think of it like a breaking news flash from the crime scene directly to the courthouse. The second the police get wind of a serious crime, they put together this quick summary and send it over to a judicial magistrate. This single report is what gets the entire legal engine started.
So what's actually in this report? Well, it's got the basics. A copy of the FIR, the name of the officer in charge, the IO. But here's the kicker, the really important part. It also includes the officer's professional opinion. Should we investigate this or not? And that recommendation, that's where the whole system pivots.
And that brings us to a major fork in the road. That police recommendation, it doesn't just go into a file cabinet. Nope, it lands right on the desk of a judicial magistrate. And this person, they're the first line of defense, the first judicial check on police power, right from the get-go.
Now, this magistrate has three main paths they can take, laid out in Section 178. Path number 1, they can just agree with the police. Yep, investigate. Or nope, drop it. Simple. Path 2, they can completely overrule the police. Imagine the police say nothing to see here, and the magistrate says, actually, you are going to investigate. Huge. And path 3, if they're kind of on the fence, they can hit the pause button and say, you know what? I'm going to do my own little inquiry first to see if this case really has any merit. And this is so important. What this means is the magistrate is not a rubber stamp. They aren't just there to nod along with whatever the police say. This builds judicial oversight right into the very start of the process. It's a safeguard to make sure cases aren't just swept under the rug. So get this. The person who makes the first critical call isn't the cop on the street. It's the judge in the courtroom. Okay, so let's say the magistrate gives the thumbs up. The investigation is on. What's next for the police? Well, they've got to start gathering information. And the best way to do that, of course, is by talking to people. We're talking about witnesses.
Now, the police can't just call you up for a friendly chat. They have the power to issue a formal written order that requires someone to come in for questioning. This isn't a request. It's a legal summons. It's serious. But, and this is a big but, that power has limits. The law puts in some really important protections. So while most people can be told to come down to the police station, that's not true for everyone. For women of any age, boys under 15, men over 60, or anyone with a significant disability or illness, the police have to go to them. They have to be questioned at home. The only exception is if they themselves agree to go to the station. It's a huge safeguard, built right into the law.
Okay, get ready because we're about to hit the most surprising, kind of mind-bending part of this whole thing. It's all about what happens to the statements you give to the police. I promise you, it is not what you expect.
Here it is. The general rule is a statement you give to the police during an investigation isn't signed, and it cannot be used as the main evidence in court. Let me say that again. It can't be used to prove someone did it or didn't do it. It's like there's a legal firewall between that police interview and the actual courtroom trial. So the question is obvious, right? If you can't use it as evidence, what's the point? Why even bother talking to the police? Well, it's because that statement has one very specific and incredibly powerful hidden use. Let me give you a quick example. Let's say a witness is talking to the police right after an incident. They say, "Yeah, I saw the whole thing. I was right there buying some apples from that fruit stand." Okay, now fast forward. Months later, we're in the courtroom. Same witnesses on the stand, under oath, and this time they say, "Oh yeah, I saw it all. I was there to pick up my kids from school." Boom. See the problem? Buying fruit, picking up kids, those are two different stories. And that is when that original police statement gets its moment to shine. The lawyer for the other side can now pull out that first statement, not to prove what the witness was actually doing, but for one single purpose, to show a contradiction. So here's the takeaway. The only thing that statement is good for in court is to wreck a witness's credibility. It's a tool for a lawyer to stand up and say, Your Honor, this person told the police one thing and now they're telling you something completely different. How can we trust anything they say? It's not about proving a fact. It's about proving a person is unreliable. It's a really clever part of the law.
All right, finally, let's talk about the safeguards. I mean, giving the police power to investigate is a big deal. So the law has to build in some guardrails, right? Some rules to protect people and make sure the whole thing is fair.
And the absolute bedrock principle here is free will. It's simple. You cannot be forced to give a statement. Period. Anything you say has to be said voluntarily. The whole system rests on that idea.
And Section 182 lays it out in black and white. Police are forbidden, absolutely forbidden, from doing certain things. They can't offer you a deal or a promise to get you to talk. They can't threaten you. And on the flip side, they also can't stop you if you actually want to give a statement. It's a two-way street.
And really, that's what this is all about when you step back and look at it. From that first decision by the magistrate, to the weird rules about witness statements, to these protections against coercion, it's all one big balancing act. The law is trying to give the police the power they need to solve crimes, while at the same time putting up a strong fence to protect our individual rights.
So, there you have it. That's the blueprint, the rules of the game on paper. It's all logical with checks and balances. But it leaves us with one final, really big question, doesn't it? These laws create a framework, but in the real world, with all the messiness of human behavior, faulty memories, and real-life pressure, how much does that perfect framework actually shape what happens in the end? That's something to think about.